Let's bring in our think tank. Joining us in Lansing, Michigan, criminal defense attorney Mary Chartier is with us. And in studio, prosecutor Jen Stevenson, law professor and former prosecutor Melissa Redmond, and criminal defense attorney and former prosecutor Marcia Minow. Welcome to you all. Mary, let me begin with you out there in Lansing. I was really impressed by Icrino and his closing argument today. Such passion, and I thought putting the pieces together. What are your thoughts?
I think Bill Icrino did a great job. I'm not surprised. Bill Icrino is an excellent lawyer and an excellent prosecutor. He was able to take all these various pieces that we have been hearing about, put them together very logically, and I think he was passionate where he needed to be. He was organized. I think he did an outstanding job today for the government.
All right, let's talk about this, okay? Did he do enough to put the pieces together? Because no one is saying they saw him fire the weapon that night. Is it going to be enough?
Yes, I think it's definitely enough. I agree with the comments. He's obviously very articulate. He's putting forward all the evidence and showing how each piece of evidence corroborates everything else. It is a circumstantial case in some respects, but I think he's done enough.
And I think what he has to do, because it is a circumstantial case, is rule out any other reasonable possibility that someone other than Stephen Washington committed the murder, and taking it piece by piece the way he did, adding in the passion that you want to have the jury remember why they're here, why this is important. I think he did a great job of tying those pieces together and laying out what each witness said, each piece of evidence, and how it paints the whole picture of why Stephen Washington is guilty.
You know what strikes me here is that this is a circumstantial identification, right? One person testifies there's a tattoo. Another person testifies, yeah, it was some guy from Mississippi. Someone else testifies that, yeah, he had that southern country accent, which the jury didn't hear, by the way, because they didn't testify. Have you ever seen a case like that where you have all these witnesses yet, and everyone's there at the time of the crime, nobody saw it?
That's uncommon. And I believe he did put the pieces together, but there's one piece I think he's missing, and it's beyond a reasonable doubt. If I am saying that a black male with a tattoo under his left eye committed this offense, and I have no witnesses that have placed a weapon in his hand or can identify him, including but not limited to the girlfriend who was screaming and wailing the entire time, so you can tell she was emotionally charged as to what was going on that evening. And she still in testimony said, can't point him out in the courtroom.
All right, where's the line between reasonable doubt in a case like this? Let's talk about the identification, reasonable doubt, and come on, 2 + 2 = 4. I mean, we've got testimony that he's in the car driving there, right? Mm-hmm. I mean, is that?
I don't think the issue is whether he was there or not.
Do we have to see everything? Like if I go to bed tonight, right, and I go to sleep, and I look at the yard before I go to sleep, and it's just the yard, just the grass is there. And then I wake up, and there's snow on there, right? Now, I didn't see it snow, but I mean, is that not beyond a reasonable doubt that while I was sleeping, it snowed?
Well, that's beyond a reasonable doubt. But the problem you have here is it's not snowing. And that's the issue. It needs to snow, and it has to snow based on testimony. Somebody has to say, I saw him. He pulled the gun. There was a young lady who was close enough to him to have testified that he hit her with the weapon, and still no specific ID. He's sitting right there. None of that.
Well,
yeah.
I think what the prosecution has to do is exactly what you said. Like, you have to bring out that, if, you know it's snowing outside even though you didn't see it snow. You know you put gas in your tank even though you didn't, see the gas go in the tank. You put the nozzle in the gas tank. You see the numbers rolling on the
Oh, I like that
tank.
one, too. That's
and
another
so
good circumstantial one.
Yeah.
Right.
And so they're going to try to convince the jury that, of course, Stephen Washington was the shooter. You have all of this, the fray going on, all of the fighting is dark. The girls are fighting with other girls. They didn't get a good chance to ID him perfectly, but they know they saw a black male, medium build, about 5'6" to 5'7", with dress and a hoodie and a tattoo under his eye. And one of them said that he had a southern accent, and you have a defendant.
And we have other witnesses saying that he was there
right,
at
I believe
the scene.
One of the Kelly sisters said he was actually there. He rode with us. He got out of the car.
That was Jessica, who had to be arrested to testify. She
Right.
didn't show up. She didn't like her subpoena.
And mere presence alone is not good enough to convict someone.
Right.
Okay. I'm just trying to put 2 + 2 together here tonight, folks. That's all I'm doing. Doesn't look like a frame job to me. But when we come back, What is the defense going to say tomorrow? We know at the beginning of this case it was all about alibi, right? I wasn't there. Is there going to be a brand new defense tomorrow morning? We'll talk about that when we come back.
Would you stand for me, please, Mr. Washington, and raise your right hand for me? Do you swear or affirm the testimony you're about to give will be the truth and the whole truth under the penalty of perjury?
Yes, sir.
Okay, you can be seated. All right, you understand and you've heard at the beginning of the trial that Judge Jamo instructed and always told the jury that you have an absolute right to remain silent. You recall that? You recall that? And that silence can't be used against you. So I would tell the jury, if you chose to exercise your right to remain silent, that they would have to make their decision based only on the information that's been presented here during the course of the trial. You understand that? They can't go back and say, gosh, I wish I had heard from Mr. Washington, because you have an absolute right to remain silent. You understand? Now, also, if you wanted to volunteer to testify, you could. Okay, so even though you have an absolute right to remain silent, you could testify, but in order to testify, you'd have to give up your right not to testify. It's one of those quirks. All right, I know it comes out funny. So if you want to testify, you have to give up your right not to testify. You understand?
Yes, sir.
It's my understanding that you have consulted with your attorneys in this matter and have had discussions, and you have decided that you wish to exercise your right to remain silent and not testify. Is that correct?
Yes, sir.
I was listening closely, trying to see if I could pick up on that country southern accent. I didn't hear anything. I only heard a couple of words. And the jury didn't even hear that. So they have no idea what Stephen Washington sounds like when he speaks. All right, my guests are back with me here. Our think tank tonight. He doesn't testify. Would you be disappointed as a prosecutor not getting the opportunity to cross-examine him?
I mean, at all times, yes, of course. You always want them to take the stand. But I think the evidence is enough here.
Yeah, something else happened. I want to get to this right away, which is that the judge today said that he's going to instruct the jury on self-defense. Take a listen.
We also had a discussion about whether or not we would give a self-defense instruction in this matter. That discussion concerned the defense's position that Mr. Washington, if they believe he was there, acted in self-defense. And so there's no testimony to show what Mr. Washington's state of mind might have been. The only testimony we have comes from Mr. Keener that he believes the deceased, he believed he saw a knife, and that he believed that when Mr. Washington and the deceased were facing each other, that I guess he testified he may have seen a lunge or something like that. So the court initially felt that without any testimony concerning the state of mind, that there would not be an appropriate self-defense, but apparently when we, on the break, we researched and it stated, the cases stated that it's not necessary that the defendant testify in order to assert a self-defense, and so the court is going to give the self-defense instruction. It's going to give the identification instruction, and in regards to self-defense, we'll talk about proof of burden of proof on the self-defense, that the prosecutor has to show that it wasn't self-defense.
Let's put a little perspective on this, okay? We were saying self-defense at the beginning of the case, but the defense was saying alibi. They filed a notice of alibi, which was withdrawn today, right? And in court, it came out, from the defendant that, he was the one telling his attorney that he wasn't there. So I wasn't there, but if I was, it was self-defense? What is that? Marshall, what is that?
Well, that's a charge that the judge has to give, because if the defense in a charge conference...
I thought a trial was a search for the truth. There's nothing to do with the truth. It's like, well, I wasn't there, but maybe if I was there, it was self-defense. What is that?
Well, a trial is not done absent the law. So you got to have law that you're going to apply when you look for the truth. The law says, as the judge thought before, that if you're going to give the charge, you have to testify. But I guess defense counsel looked like he had done his homework better than the judge had, because after the judge looked at the case law, he
Right,
realized,
but what is the defense doing here? What is this, like the shell game where we're trying to figure out what the defense is? Oh, there's alibi. Wait a minute. No, it's self-defense. How can it be both? How can it be self-defense if you're not there?
I really think this is a situation where the defense is hamstrung by their client. And I think there's a reason why the defense didn't commit to alibi in their opening statement. And they talked about this frame job, and they really focused on the lack of reasonable doubt. Because I'm sure
Well, they also
knew.
mentioned that Angela Kelly was going to say he wasn't there. Or
Right.
was in the car.
Well, I don't think he talked about Angela Kelly in the opening statement.
I heard him say something
no,
about...
he didn't talk about
I heard a
Angela
little
Kelly. He was
something.
hoping Angela Kelly would testify,
Right.
but when she invoked, that's when
All right.
that's off the table.
Mary, prosecutors have to prove the case beyond a reasonable doubt, but my understanding is that the defense and defense attorneys have a unique advantage in that they have the person accused. So the person accused can tell you what happened, right?
Well, they can tell you if you really want to know what happened. I mean, there are some instances where you don't want to know because that does limit what you can put on in terms of your defense. Here, if the client was telling his defense lawyers, I wasn't there, alibi was obviously on their mind because they filed the notice, I think Mr. Keener provided enough information and enough testimony that self-defense is a good jury instruction in this case. Now, once the jury instruction is read, the burden shifts over to the prosecutor to prove that it wasn't self-defense beyond a reasonable doubt. I think if there are those conflicting defenses, I wasn't there, but if I was there, it was self-defense, I think that does weaken the self-defense claim.
Yeah, Jen, what would you do in your rebuttal argument if the defense got up there and said, ladies and gentlemen, Stephen Washington was not even there. But if he was, he killed in self-defense. How would you respond to that?
So I love it when the defense does that, because the truth is the truth. It doesn't change throughout the trial. It is what it is. While the prosecution bears the burden of proof, and while legally, yes, they should give self-defense instruction for many reasons, including to protect the guilty verdict that's going to come and not have it be turned over on appeal for a failure to properly charge the jury. But when the defense gets up there and says, he wasn't there, and if he was there, it was self-defense, it makes their client sound completely guilty.
Are they going to make that argument?
I don't think that's going to be the argument.
So how do you get in front of this jury to think about self-defense, which I will admit is a better defense to this case than alibi?
It absolutely is. And
So do you argue self-defense and just get rid of the alibi at this point?
well, if you withdrew the notice of alibi, you could just get rid of the argument about alibi because you've already withdrawn it as far as the case is concerned before the court. So my defense would be it's self-defense. And I'm telling you, after the evidence comes out, because nobody knows what the evidence was going to be, but now that the evidence is before you, ladies and gentlemen.
But in self-defense, the defense knows what the evidence is.
Well, not
Well, you-
necessarily, because you don't know what the testimony
Hey, you
is
don't
gonna
talk
be.
to the guy that sits next to you during the whole trial?
Well, you gotta believe the guy is sitting next to you in trial, and you're not certain what the other witnesses are gonna say your guy said. And because everybody knows that perception is everything, and that what you perceive even in this setting, and what I perceive in this setting can be different.
But I think what the defense is going to have a hard time doing is explaining why he didn't cross any of the witnesses on self-defense, on what the victim was doing. What was he doing with the scissors? Did anyone else see him with the scissors or the knife?
Yeah,
that,
it's
Mr.
pretty
Keener-
much Keener's
Yeah,
the only
Keener's
one.
the only one that mentioned the knife. So
A little bit of that.
yeah, did anyone else see that? Did anyone else see this lunge right before the gunshot? So he would have to explain if it's self-defense, if he's going to go with self-defense in his closing. If I'm on the jury, I'm wondering why is this the first time he's mentioning self-defense?
Self-defense, yeah.
So these aren't the only two defenses that have been put forth by the defense in this case.
There's more.
He's also blamed two other witnesses in front of the jury of being the actual shooter.
Right.
Right.
So we're now at defense number 4.
So, Mary, does the defense get up in front of a jury and say, ladies and gentlemen, sometimes, like my friend Vinny on Sundays, he cooks some spaghetti, and you take the spaghetti, right, you boil it, then you put it in the strainer, right, and then if you don't put enough olive oil in there and you throw it against the wall, some of it might stick.
Well, he's not going to necessarily talk about your spaghetti cooking, I think, on Sunday. I think the notion, as one of the panelists just indicated, about sort of the shifting defenses as the trial has gone on, that's going to be, in my opinion, the most problematic thing to overcome with the jury. I think it would have been, and we're always, of course, looking in hindsight back, but I think it would have been more ideal if they hadn't been sort of indicating that Mr. Melton was the shooter or someone else was the shooter, and just had asked the questions and seen how the testimony came across, and then put forth the self-defense at the end. I mean, that's Monday morning quarterbacking, but I think it's going to be tough to say, listen, we're threw it all out there to see what stuck. I don't think they're going to be able to do that. But I do have confidence in Toby White. I think he will deliver a passionate closing, and I think that he will try and do his absolute best for the client, given the constraints that he's had to work with.
All right, and one more tip, folks. If your spaghetti does stick to the wall, you cooked it too long. You got to serve it al dente, to the tooth. All right, you heard enough from us. When we come back, we hear from you. Social media reaction to the prosecutor's closing argument when we come back. We get to social media reaction today, closing arguments by prosecutors. And one of the big questions out there is, did they disprove self-defense? Because that is something that prosecutors have the burden of doing. We get right to Raven, who writes, Vinny, this case is so mind-boggling. Those jurors have their work cut out for them. I'm convinced that the defense didn't really have to disprove anything. In my opinion, the prosecution pretty much laid out a not guilty for Washington from day one. Every witness can either say, yes, it was him I seen there, but didn't see a gun, or I saw a gun and I can't recognize Washington. Just because the shell casings were in the car, that doesn't prove they were his. I think someone videotaped all this, but will never come forward. I feel Washington was just used as a scapegoat. Mary, that's one thing that's really not bothered me, but kind of confused me here. I mean, everyone walks around with a camera these days because everyone has a cell phone. And there's no video, no surveillance, nothing of this whole thing. Do you think there's a video out there that someone either erased or doesn't want to come forward with?
No, I really don't think that there is a video. I mean, people videotape everything, but this was such a brief period of time. So none of the people who are actually participating would likely videotape it. And people in their apartments, they wouldn't be videotaping anything unless they thought it was something interesting going on outside. I really don't think there's a videotape that someone is holding back or that has erased.
Debbie writing tonight, they couldn't prove anything except reasonable doubt. There's obviously more to what happened than what the prosecution found. Ivan and Jessica definitely need to be sentenced too, and at a later trial. I think this will be a hung jury. I don't feel the prosecution proved the case against Washington. All right, Jen Stevenson, you're the prosecutor. What do you do if you've got jurors out there who might be thinking that there's more to what happened than what everybody said, that there's like more to this story that we just don't know?
So I don't think there's more to this story. I mean, girls got into an argument, people's feelings got hurt, and they sent people to beat them up. That actually happens like quite a bit, and all of us know as prosecutors. I am concerned that the general public might not know that.
So how do you let the jury know that? Is there a way to get through to the jury that this isn't such an unusual situation without crossing a line?
No. However, all of the witnesses corroborate the first part, right? The first confrontation, that's consistent. The only time that we have a problem is we have a problem with identification of the shooter, direct identification. I saw him shoot. But that is explained by the fact that everybody at the second location is busy. They're in the middle of a fight.
Great point. Pauletta writing tonight, I was moved to see Isai's father make it in time for closing arguments. My heart bleeds for him. The prosecution delivered a very compelling closing argument. So the defense needs to bring their A game, in my opinion. Who can tell who is telling the truth? Failure to place a gun in Washington's hand is big for the defense. If I'm a juror and the state drops the most serious charge, which they did in this case, first degree down to second degree, I'd be inclined to believe they didn't prove their case beyond a reasonable doubt, and my vote would be not guilty or a hung jury. It's a doozy, just my opinion. Marsha, how about that? The fact that first degree is now off the table and it's a second-degree case.
That's an issue because jurors are going to start saying, okay, there's a problem with the state's case. And based on that problem, the state is now starting to back off. And they're asking us to convict
Can you
somebody.
argue about that? Can you make that argument to the jury that, hey, this was first degree, all of a sudden it's not first degree?
Well, it depends on what you want to focus on. As defense attorney, I wouldn't necessarily focus on that. I would have the jurors draw the inference because I like you drawing the inference than me coming in and trying to tell you that, my guy was there, he wasn't there, and then now look at the states. It's too much mud.
Allison writing, Vinny, yes, I believe they disproved self-defense for the simple fact that in order for the victim to have had his knife out, he would have had to put it back in his pocket after he was shot and before he dropped to the ground. But one thing bugs me about the state's closing is that they want the jury to believe some of Ivan's testimony, but not all of it. I still feel there's reasonable doubt all over this case. Also, Vinny, today's my birthday. Happy birthday, Allison. But how about the disproving self-defense? I mean, that knife was found in his pocket folded.
Right. But no one explained where the scissors were, how the scissors were in his pocket. Is it something where he could have accessed easily? But I think
But he still would have had to put them back in there. So if I'm in a standoff with you and I'm holding a knife or scissors, I get shot, I'm like, oh, I've been shot, I better put the scissors away?
No, I think he was turning. I think he was running when he saw the gun. And I think that's why self-defense is problematic, even if you have Mr. Keener saying that I saw him raise a knife or I saw him raise something towards Mr. Washington before the shot. He's still saying I saw Stephen Washington with his hands up in a motion indicating he had a gun right before I heard the shot. So I think either way, self-defense is a problem for them.
All right, Judas, I think I'm saying it right, Judas. I like the last name, Kiss. I believe there was another knife and someone picked it up. Maybe to make it appear he was unarmed, maybe just because. Remember that Isai's girlfriend was mad at him and calling him out for not backing her up with Ivan. Maybe when Ivan and the cousins came, he wanted to impress her, but he brought a knife to a gunfight. Mary, do you think there's any chance that there was a knife there that someone picked up after the gunshot?
I mean, that seems to be a fairly plausible argument. I don't know how likely it is, but Mr. Keener said he saw a knife or something in the decedent's hands. Everything is happening so quickly. And I mean, we see that with law enforcement officers who are trained, who wind up shooting predominantly a lot of African-American men when they think that they have something in their hand and it turns out to be nothing or a cell phone. So I think, everything is going along so quickly. Was there a knife that fell out of his hand when he fell to the ground and then someone picked it up? Quite possibly. Although I think the chaotic nature of the scene where, when you hear that 911 call and then you hear everything that's going on, did someone have the presence of mind to take that knife? I don't know. But I think it certainly is plausible that happened.
Is there a reason for Ivan Keener to lie about the knife?
Absolutely.
What is it?
You don't want first-degree murder.
But he wasn't charged with anything.
Right, but you could be, because remember, your immunity only was based off of just the testimony you were going to provide at trial. I didn't realize initially.
So you think he's protecting himself by making up that story?
Absolutely.
That's problematic. That's a big
I think he's more
problem.
protecting his cousin's boyfriend. I think he can't say that Washington wasn't there. He can't say, he wants to say or testify to what he saw about him raising the gun. That's why he won't admit that he saw him actually shoot or that he saw a gun in his hand. I saw his arm raised in a motion indicating a gun, but I didn't see the gun. I didn't hear the shot, but it was
This is interesting. This is the exact opposite of what the defense is sort of arguing, because the defense is saying that they're all framing him.
Right.
Yet you're saying they're trying to do everything, he's trying to do everything to minimize.
Right. He's trying to minimize Washington's involvement, but he can't out and out lie because one of the Kelly sisters already said that they were all together. They all came together. They all left together.
I think he feels guilty. I think he feels guilty, and that's why he threw
He
threw him a little self-defense bone in his preliminary testimony that he saw, the alleged victim.
Right,
lunge
he
at
shot
him.
him, but it was probably self-defense.
Right.
Yeah.
So that's my issue with Keenan.
But I don't think it's going to fly.
Scarlett writing, yes, they disproved self-defense. All the shooter would have had to do was brandish the weapon or fire a warning shot if he was threatened with a knife. The shooter fired a shot, way more than what would have been necessary to stop the person with a knife. Here's the question I have. Someone comes at you with a knife. Do you have the right to shoot him in self-defense?
Depending on the circumstances, yes. But I think in terms of the self-defense, we have another aspect here, which is the concept of imperfect self-defense. Ivan says that he yells out, he has a knife. So then you start thinking about what the defendant thought, whether or not the victim actually had a knife.
All right. What a day inside the courtroom, but who had a better day? Was it the prosecution or the defense? You know, there were some decisions by the judge. Prosecutor made his argument. Our think tank will answer that question when we come back.
It's my understanding that you have consulted with your attorneys in this matter and have had discussions, and you have decided that you wish to exercise your right to remain silent and not testify. Is that correct?
Yes, sir. So I was led to the second story of the house, knocked on Hannah's door for several minutes. Door finally opened. She was very intoxicated. She couldn't stand up straight, kept losing her balance. I started asking her questions. Specifically, I needed to know what Ivan's last name was.
What, if anything, did Ms. Michener tell you when you spoke to her or attempted to speak to her?
She told me to off and get out of her house.
Please tell the jury exactly what happened when you got to Ivan Keener's residence that morning.
As Detective Kuhn and I approached on foot, we could smell marijuana. It smelled pretty thick and strong.
People arrested, we have no rebuttal, Your Honor.
Okay, and the defense rests?
We do, Your Honor.
I'm so upset with this defense.
Oh,
this revolt, because they start off with self-defense, they go to alibi, now it's shoddy investigation, but wait, we're kind of back to self-defense because we're asking for the jury instruction. I don't like it. It's messy. It doesn't send a clear message to the jury. I'm upset.
Yeah, you're
I'm
absolutely right. It's
I'm
been
upset.
inconsistent.
And then they don't call any witnesses. It's over already. Where was Hannah Michener? Where was she? Anybody know? Anybody want to know where is she?
Murder, ladies and gentlemen. The murder of a 22-year-old college kid over nonsense. What she was able to observe is a black male subject. She described him as a black male, brown skin, more dark than light, 5'6" to 5'7", medium build. She saw a gun in his hand. He was holding it in his hand. He was waving it around, and it was obvious that he had a gun. Detective Thomas is specifically able to observe that this defendant, Stephen Washington, has a tattoo under his eye. A tattoo under his left eye, ladies and gentlemen. There could not be a more unique marking on a human being. Ivan Keener acted in the most despicable of ways that you can act towards other human beings. His conduct was petty, it was insecure, it was revengeful, it was assaultive, and it set in motion an event that ended with lethal and tragic consequences over nothing, over his ego, over his petty disputes. Ivan Keener identifies the defendant, Stephen Washington, as the individual who shot and killed Isai Barones. If Ivan Keener were going to frame Stephen Washington, this is either the singularly most preposterous frame job that's ever been done, or he is doing something different. If he wanted to frame Stephen Washington, why not make up a good story? Stephen walked up and said, "You're gonna die, it's time to die tonight, pal," and stood over him, ha ha, and got in the car and left. If you're gonna frame somebody up, he's the irrelevant guy. I mean, really frame him up here. We are going to ask you to hold this defendant accountable for the senseless, tragic, ridiculous, and violent death of Isai Barones on the night of October 12th of 2018. And we are asking you to hold this defendant accountable by a verdict of guilty of second-degree murder, guilty of carrying a concealed weapon, and guilty of felony firearm. Thank
you. Big day out in Lansing, but who had a better day, the prosecution or defense? Let's bring in our think tank, and we begin in Lansing, Michigan. Mary Chartier, prosecution or defense today?
Tonight, I'm going to say the prosecution had a better day. I thought Bill Creno's closing was extremely compelling, and I am a defense attorney, you know, through and through in my DNA. But I thought he did a fantastic job. He was organized. He used visuals, which I really like in closings. He was very, very good. He anticipated some of the defense arguments we're likely to hear tomorrow. He tried to shut them down. He was passionate when he needed to be. I thought he was excellent. I thought he did the absolute best job any prosecutor could in this case. And I thought he did a great job. I think prosecution won the day for me.
Marsha Minow, criminal defense attorney. Who won the day today, prosecution or defense?
I say defense, and based on your key witnesses being told to the jurors that he's egotistical, he's petty, he's horrible, that's your key witness. You're reducing your charge to second degree. The judge gives an instruction regarding self-defense, and the defense has no burden in this case. Defense.
All right, Melissa Redmond, former prosecutor, law professor, who had a better day.
I have to agree with Mary. I think the prosecution the prosecution was very methodical in how he laid out his closing argument, addressing the witnesses, both three who didn't know him, two who did know him, all put him in the scene. He talked about the ballistic evidence, the bullets in the car matching the bullets at the scene, the fleeing right after the police visited the Keno residence. I think he did a good job of piecing together the puzzle to convince the jury beyond a reasonable doubt that Stephen Washington was the one who committed this murder.
Prosecutor Jen Stevenson, who had a better day.
Prosecution had a better day. The closing argument that was delivered was excellent. In addition, the state does not pick the circumstances of a murder. Those are picked by the defendant. This is a very sympathetic victim in this case. The jury's going to want to get it right, and they have enough evidence to do so.
All right, I'm going to agree. I believe it was the prosecution today. And the reason I say it was the prosecution is when you are arguing a case to the jury, okay, you are the spokesperson. You are trying to get them to believe you. And I always believe that in order for the jury to believe you, you've got to believe you. And I've seen attorneys here on CourtTV, in some of the cases we covered, they were so detached from the case that they were trying. That was not the case today. I mean, he was all in. You could tell that he is convinced beyond a reasonable doubt. And I really believe he was able to convey that today to the jury. And I think that is so important. Now, there were some good points for the defense and some opportunities for them, especially with self-defense now rearing its head into this case, which is what all of us here at CourtTV have been saying from the beginning was the best defense in this case, because the star witness for the prosecution is the one who lays out self-defense. So they had some points, but overall, passion, believability, and credibility